Good afternoon and good morning to those in California. I want to welcome California Attorney General Rob Bonta, Michigan Attorney General, New Jersey Attorney General Davenport, Jennifer Davenport, Rhode Island Attorney General Peter Nerona. I want to thank them all and their staffs for collaborating on this action. A special thanks to Deputy Solicitor General Alex Hemmer and Assistant Attorney General Mike Tresnowski from my team for their work on this matter. We are here today because President Trump refuses to listen to the courts when they tell him that he cannot exceed the authority of his office and he cannot extort states into doing what he wants. For the third time, he's putting at risk our national security and the security of our states by targeting billions of dollars in funding, including over $1 billion from the Homeland Security Grant Program. The Federal Emergency Management Agency and the Department of Homeland Security are again trying to impose unrelated and unlawful conditions on funds that Congress appropriated for the states to prepare for and respond to emergencies and natural disasters, including acts of terrorism. Illinois receives over $40 million of this funding each year for state and municipal efforts to prevent, prepare for, and respond to disasters, acts of terrorism, cyber attacks, and other emergencies. Our coalition is filing yet another lawsuit today to protect this funding and the people of our respective states. In our lawsuit, we allege that the administration's actions exceed its authority, are arbitrary and capricious in violation of the Administrative Procedures Act, and violate the spending clause of our Constitution. The conditions DHS is trying to impose would require states to make sweeping changes to the way we conduct elections, including rewriting state election laws and privacy laws. These requirements would force states to abandon years of work and millions of dollars of investments in our election systems. States would be required to turn over our voter rolls to the Department of Homeland Security, something even Republican-led states have declined to do. States would also be forced to use our critical law enforcement resources to assist DHS in enforcing federal immigration law. And the conditions would permit DHS to terminate any federal grant at any time for any reason. Despite our coalition already winning 2 lawsuits in this past year that protected the same funding, the Trump administration still thinks it's above the law and can hold funds hostage to push its policy priorities. Despite several federal courts, including 7 judges appointed by President Trump himself, telling the administration they cannot demand our state voter rolls, the president continues to try to force states to provide them. Despite federal courts ruling the federal agencies do not have the power to unilaterally freeze or cancel funding appropriated by Congress, the administration continues to try to unlawfully claim such power. Congress holds the power of the purse, and state legislatures set state election laws. Congress and individual states, not the president, have the authority to oversee the election process. No amount of bullying from the president will change these facts. Yet President Trump refuses to accept the reality of our democracy and instead insists on wasting state and federal resources when he frequently, consistently, and willfully violates the law and our Constitution. I am disappointed, but not necessarily surprised, that our coalition is filing its 3rd lawsuit today to protect this funding. No matter how many times the president tries to unlawfully impose his will upon the states, I will stand with my fellow attorneys general to uphold the law. And I will continue to fight for the safety and well-being of the people of the state of Illinois. I want to thank again my fellow attorneys general who are here today for their leadership and introduce my friend and colleague, California Attorney General Rob Bonta.
Thank you, Attorney General Raul, for the introduction, for your leadership, for your partnership. And as AG Raul mentioned, we're once again joining forces to take the president to court. This time, of course, we're challenging his latest unlawful attempt to hold critical emergency preparedness funding hostage in order to force states to adopt his agenda, his policy agenda, his political agenda. And for California, this marks our 79th lawsuit against the Trump administration. We're talking about, in this case, billions of dollars in federal emergency preparedness and homeland security grants at stake that Congress, a separate branch of government, established to help states and local governments prevent, prepare for, respond to, and recover from emergencies ranging from wildfires and earthquakes to terrorist attacks and other catastrophic events. And instead of ensuring these critical resources reach the communities that need them, Trump is attempting to use this funding as leverage to force states to adopt his preferred political agenda. That is unlawful, it's unconstitutional, and today we're asking the court to stop it. The Trump administration is trying to attach unlawful, unrelated conditions to emergency preparedness funding that Congress intended to keep our communities safe. It's attempted to use critical federal funding as leverage to force, it's attempting to use critical federal funding as leverage to force states to carry out its preferred policies. The problem is Congress, not the president, determines the conditions attached to federal funding. And the federal government can't force states to choose between protecting their residents and surrendering their constitutional authority. Courts have already rejected two similar attempts by this administration to impose unlawful conditions on these very same grant programs, not to mention the unlawful conditions the Trump administration has tried to place on other sources of funding. This is a repeat offense for this administration. They are a repeat offender when it comes to this type of unlawful conduct, trying to impose conditions on funding where those conditions are unlawful and outside the scope of the authority of the president. And so we're back in court to ensure that these funds are distributed as Congress intended, not conditioned on an unlawful political agenda. These grants help communities prepare for emergencies before disaster strikes. They support emergency management personnel, strengthen disaster response capabilities, improve coordination among first responders, and help protect our residents when they need government the most. This means our communities would have fewer resources to prepare for wildfires, earthquakes, floods, terrorist threats, and other emergencies. Public safety should never become a bargaining chip. Emergency preparedness funding should be based on public need, not political agendas. California has consistently defended the rule of law when the federal government exceeds its constitutional authority. At the end of the day, this case is about ensuring that emergency preparedness resources remain focused on what Congress intended, helping states protect the people who call them home. I'd like to take a moment to recognize my incredible team leading this work, including Delbert Tran, Dalen Thrift Viveros, Jesse Bosbaum, Lisa Ehrlich, Jim Stanley, Lee Sherman, and Michael Newman, a great team doing great work. Proud to call them my colleagues and grateful for their leadership on this and so many other cases in our office. And with that, I want to say thank you for joining. And it's my honor and pleasure now to pass it over to my incredible colleague, New Jersey Attorney General Jennifer Davenport.
Thank you. I am grateful to be here with Attorneys General Raul, Bonta, and Noronha. You see a lot of AGs together on the screen today because the lawsuit we're announcing is so core to our mission, as you've heard. As Attorneys General, we protect public safety and we defend the law for each of our states. And working together, we make the whole country safer. That's what the president is supposed to do too. But instead, the Trump administration is attempting to impose unlawful conditions on crucial homeland security and disaster preparedness funding and deny funding based on his political preference. For decades, the partnership between FEMA and the states has been the backbone of our nation's disaster prevention and preparedness system. FEMA grants help pay our first responders, protect our schools and houses of worship, and strengthen our cybersecurity. This federal funding is not just numbers on a spreadsheet. It is the shield that keeps New Jerseyans and all Americans safe from disaster. FEMA always supported all states until President Trump started trying again and again and now again to use Homeland Security and disaster prevention funding as a political weapon to force states to comply with his unrelated political priorities. Last year, the Trump administration tried to force states to cooperate with federal immigration enforcement by threatening to cut off disaster funding. The courts called it what it was: unconstitutional economic dragooning. Next, the administration tried to cut millions of dollars in counterterrorism and disaster preparedness from states they disagreed with. Again, the courts stopped them. Now, FEMA is trying the same thing yet again, imposing even more radical conditions on Homeland Security funding. They're trying to dictate how states run their elections. For example, requiring states to use hand-marked paper ballots, or else FEMA will withhold 20% of this critical security funding. They're demanding that states participate in federal immigration enforcement in violation of New Jersey law and in spite of prior orders barring very similar conditions on this same funding. And they're even trying to give themselves effectively unfettered power to terminate these crucial grants based on, quote, agency priorities, a repeat play that a court just struck down just last week, ruling in our favor in another case. This type of termination power would make it impossible for states to count on billions of dollars in terrorism and disaster prevention funding. None of this is legal. Congress never authorized FEMA to rewrite state election laws, to force states into participating in federal immigration enforcement, or to terminate funding on a whim. These conditions violate the Administrative Procedure Act, ignore the Constitution, and threaten the safety and security of all Americans. So we're doing what we do best: protecting public safety, protecting our crucial funding for first responders, emergency operations, and for counterterrorism and cybersecurity, and keeping all New Jerseyans and Americans safe. I'll now turn it over to Attorney General Noronha.
Thank you, Attorney General Davenport and Attorney General Raoul and Attorney General Bonta for your leadership and partnership on what is yet another case against the Trump administration. As Attorney General Bonta said, all of these cases to me are trees, but when you go up and look at the forest, what they say to us as Americans and to us as Rhode Islanders is this: that the president is trying to take power to himself and to himself alone. Repeatedly, he has sidelined the Congress when it comes to federal funding, and he is attempting to sideline the states when it comes to how we run elections in this country, which our founders assured an important state role in those obviously very important elections. Time after time, the president has tried to condition federal funding on things that advance his radical agenda. But what he seems to forget is that federal money does not come to the federal government by magic. Federal taxpayer dollars originate in Rhode Island, in New Jersey, in Illinois, in California, and in every state in this country. And Rhode Islanders, through their elected representatives, as the people of all of our other states, are entitled to that money back in the way that Congress deems appropriate, not as this president or any other president deems appropriate. That is what the law says, and that is how the law has been consistently interpreted against this president across the country in the cases that we've brought, many of which have involved funding that the president has effectively tried to steal from the residents of our states. We refer to this case as FEMA 3.0, and it's because it's the third case that we have had to file here in Rhode Island, in the federal district court here in Rhode Island, to force the federal government to return to this state and to our fellow states monies for emergency preparedness. We are a coastal state. We face a hurricane season every year, and to protect ourselves from domestic and foreign terrorism. That's what this money is for. It's to keep us safe. And in the prior two cases, one judge appointed by President George W. Bush, another appointed by President Trump himself, have ruled convincingly, strongly, that what the president has done here has broken the law. We have been granted summary judgment in both of those cases, and a permanent injunction has been issued by the federal court. and they remain in full force and effect. So I'm confident that we will win this case again, that FEMA 3.0 will turn out like FEMA 1.0 and 2.0, and the president's unlawful actions will be found as such, and these important monies, will be delivered to Rhode Islanders and Americans all across this country. And so again, I'm grateful for the partnership. I'm grateful for the work here in Rhode Island by Paul Miowski, and Sarah Rice and Kate Sabatini. And I'm grateful to them and their colleagues. And with that, I'll turn it back over to Attorney General Raoul.